This is Attorney Mike Gravel coming to you from Chicago. As usual, today I've got a fun one. It was sent to me by Dammer over in Discord, and it's a follow-up to a prior video I did called 100%. I'll put a link to that in the description below or a card up or something like that. Anyway, it's good. This defendant is representing himself. He's not doing a very good job. Let's do it.
The individual signed in as Robert's iPad. You are in court. You need to be dressed.
Mr. Walker?
Yes, Your Honor. We're on today for a couple of things. First of all, Judge Mustashkin did hear Mr. Tracy's motions to dismiss, and those were denied, but we ran out of time and my motions to join were not addressed. The other thing that we're on today is for omnibus, and of course it's a little difficult procedurally. I think the court understands that I'm reticent to speak with Mr. Tracy in a non-public forum to deal with these procedural issues because of Mr. Tracy's being pro se. I don't have an attorney to speak with, but I do have omnibus orders here.
Okay, it's an awkward way of saying usually counsels will contact each other outside of court and try to work out issues, but he's saying, I can't really do that, because the guy doesn't make a lot of sense.
I'm going to ask the court if the court is not ready to make a decision on my joinder motion, maybe we put it on another day.
There was an argument today on that, I thought.
I can certainly give argument on that today if you're ready to hear it.
I'm ready to hear it.
All right. So the vast majority of the evidence in this case is all the same 2 or 3 witnesses, and most of that is proving the defendant's priors and the no contact order. In prior hearings, Mr. Tracy's asserted he would be prejudiced. And I'm just going to point out to the court that previously, and this is something that, for the omnibus, but previously he's not indicated that he's going to stipulate to his prior convictions or to this domestic violence no contact order. And, the jury's going to be instructed in every one of these things that they're not to take into account, his prior convictions or the other charges for anything except for the truth of that, of the charges for the purposes of the no contact order violation, and not to continue to consider the other charges against one another. But, just objectively, it seems like it's far more prejudicial for him to not stipulate to his prior convictions in the no contact order than to my allegation that he's violated the order 3 times. The witnesses are the same in almost every case. It's the protected party. It's the people that I need to call to prove the no contact order was served on him. And it's the same victim and the officers. Generally, they would show up and he'd already be gone. Mr. Tozier's and one of the witnesses to the assault and violation of the no contact order. So I think I've got 2 or 3 witnesses that are not common to every charge here. So that's what I've got that's my argument for it, Your Honor. It's strongly in the interests of judicial economy to join all these charges.
All right, thank you. Mr. Tracy, the state is moving to join and consolidate all of the charges against you into a single proceeding. Do you wish to respond to that motion?
Yes, I believe if I'm doing this right, I would object to that because all of his witnesses that he's talking about are the Hope Police Department. And that would be the witnesses that he's talking about that are the common denominator in all these cases. These are all separate circumstances with separate victims. None of them are in the same circumstances. So for them to be joined together would 100% be prejudicial against my case, and it would not allow me to have a proper, fair chance at trial.
Okay, this is what I laughed at him about in the first video, because he just said it was prejudicial and stopped there. And I found that funny. To his credit, he goes farther and he sort of says why he thinks that. I will give him credit that it was rational to that extent, starting with, if I'm doing this right. It was hilarious. And also saying that they're all separate victims, presuming that he's guilty is also a very poor play, but he does articulate his argument here. I'll give him that.
And don't forget to hit like and subscribe, or the dogs get it.
All right, thank you, Mr. Tracy.
Thank you, Your Honor.
The court rules are rather clear on these kinds of motions that multiple offenses may be joined in at trial, or for that matter, in a single charging document if they are of the same or similar character, even if not part of a common scheme or a single scheme or plan. And that's clearly been established by the state here. There's no reason to have three trials on these three cases when they contain so much overlapping evidence and identical witnesses. So I'm going to grant the state's motion. All three of these cases will be joined for trial. Mr. Walker, the trial in cause number 21-1-274 is set for jury trial to begin on June 22nd. I am now going to order that all three of these cases be joined and tried beginning on June 22nd at 8:30 a.m.
Can I say one more thing, Your Honor?
No, I've already ruled, Mr. Tracy. Mr. Walker, Mr. Tracy, you're going to be found in contempt again. Knock it off. Mr. Walker, previously we had an evidentiary hearing regarding Mr. Tracy's conduct toward Mr. Festi, and as you know, I made a finding that his conduct constituted extremely dilatory conduct, and he had forfeited his right to counsel. You prepared findings, conclusions, and an order setting forth my ruling, but it was only in one case. I don't know if there was a mistake in the filing or if it's just not showing up in Odyssey, but that order finding that Mr. Tracy forfeited his constitutional right to counsel only appears in one of those three cases. So we need to remedy that.
I think, okay, Your Honor, I think what had happened is I prepared one, and if it was going to be acceptable, I would file duplicates in the other two, and I probably just forgot to do that. So I'll fix that.
Yeah, let's fix that. All right, now regarding omnibus, Mr. Tracy, the omnibus order requires you to disclose your witnesses. Have you done so yet?
Yes, I filed multiple motions. None of my motions reached the courts. I don't have access to a law library. I filed a motion on the 26th of April of my...
Mr. Tracy, I didn't ask you for a speech. I asked you if you've already provided the prosecutor with a list of witnesses.
Yes, Your Honor, and I don't know if they got to them.
All right. I don't know either. It's your obligation to see that they do. I will tell you, Mr. Tracy, I received an envelope of documents from you late last week, and I can tell you that sending documents to me is not the appropriate way for you to file motions with the court. And what you send to me does not constitute a motion to the court. You must file motions with the court clerk. You must provide adequate notice to the prosecutor and attorney, something you did not do with the documents last week.
Those documents from last week were my grievances saying that I do not have access to a law library, where your court administrator said I did.
Mr. Tracy, once again, I'm not a law library. There is a law library at the county jail. If you're having trouble accessing it, I suggest you Mr. Tracy, you are now in contempt of court. Be quiet. Listen to what I'm telling you.
All right, he does a fine job, but I've got a little clip here where we can imagine what Judge Lanice Bryant would do with this situation.
Ma'am, please stop. Listen, first of all, stop talking while I'm talking. That's number one. Number two is stop, ma'am. Stop pushing buttons. Stop.
If you need assistance, you're going to need to get it from someone other than me. It is not my job to assist you as you prepare for this trial. You may contact the Department of Public Defense and request assistance from them. Whether they will be able or willing to provide it to you is between you and them, not me. So if you feel that you don't have access to adequate materials, you need to contact someone other than me. I am not sending you a laptop. I am not sending you a cell phone as you've requested. You are on your own. By reason of your own conduct, you are on your own. All right, that's all for today. I'm going to set a pretrial conference for May 23 at 2 p.m. We'll see you back there.
Judge, I didn't catch that date. Judge, I didn't catch that date.
May 23 at 2 p.m.
How am I supposed to actually prepare myself for trial if I don't have any law material, Your Honor? This is crazy.
Mr. Tracy, you're the one that forfeited your right to counsel, not me. You've created the problem you have, not me.
I object to this whole hearing. Let's go. I'm done. You guys are corrupt, man. Get it dry.
All right, Mr. Walker, please prepare another order on contempt. The sanction will be 30 days without credit for toward any time he's serving.
I'll do that, Judge, but and I'm sorry, but when you're...
Well, there you have it. He got himself another 30 days on a contempt charge, and he says he's not getting credit for any of that. So he's tacking that on to whatever else he's got. He actually, he had it coming. I actually like the way this judge handled it. He didn't get upset throughout. He just mentions to him, now you're in contempt, and then the guy carries on. As the hearing was ending, I thought he's going to forget about the contempt and just let it go, and he probably would have. But he had to blow up yet again, and that's what you get. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.